Hi, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to give you some tips about how you, together with your attorney, can prove damages and get more compensation for your pain and suffering. One of the largest categories of damages is pain and suffering. This is known as non-economic damages, because economic damages would be lost wages or future medical costs, because those are economic and you could put a number on them, right? You know what you make per year, and the doctor can say, this is what a surgery will cost. So those are like finite known numbers, economic, whereas pain and suffering is a little bit more mercurial, I would say, right? A little bit more like cloudy. It's not finite, it's not definitive, it's open to interpretation. What is someone's pain worth? And one of the things the defendants like to do is they like to say, you're not really that hurt. You're making this up. You're malingering. You're trying to play the lawsuit lottery. So they try to lower your ability to receive non-economic damages by, calling into question and calling into doubt your credibility. The fact that they're saying you're not really that hurt. You know that you can get a lot of money, so you're just out there to make a buck, right? So the way to really combat that is to show the type of person you are, and to show that through yourself, as well as before and after witnesses that are independent, people from your job, coworkers, people that don't have any stake in the game, right? They're completely independent and neutral, and there's no reason for them to be lying. Now, the other thing they like to do is they like to frame the case as, how much are you going to get, right? And then, it gets the jury thinking, oh, if I return a verdict of, let's say, $10 million, it's all about how much this person is going to get. But that's not really the question. The question is not really how much you're going to get. The important question to ask is, what is the value of what was taken away from you, right? Because originally, nobody wanted to be involved, let's say, in a truck crash. Nobody asked for this, right? This is just something that was thrust into your life unnaturally due to the negligence of the defendant. So then if they took all this away from you, they took away your health, they took away your freedom, what is the value of that? What is the equal trade dollar value of taking away someone's freedom, someone's health, someone's life, essentially, right? In the Constitution, we have life, liberty, and the pursuit of happiness. So life includes things like freedoms and choices, the freedom to be pain-free, the freedom to do what you want to do. And it includes liberty, the liberty or the freedom of moving around and being free and not having pain, as well as the pursuit of happiness, right? Being happy, having passions, whether it's activities or people in your life that you want to spend time with. So essentially, what the defendants also like to do is they like to make it about what you cannot do, right? And they ask you in the deposition, what are some of the things you cannot do? Well, unless you're like paralyzed, you're still going to be able to do most things, right? It's not like you cannot do anything. And if you testify, I cannot do X, then guess what they do? They send their investigator out with a camera and a video, and then they videotape you doing X, and they say, look, you're a liar. And it goes into their narrative, right? The way they want to frame everything. You're a liar, you're a cheater. So a lot of times when I prep my clients for depositions, I don't tell them to say that they can't do something. And rather, what I do is I have them talk about the experience of doing, right? So they could still, let's say, go to the store and buy bread and buy milk, but it's the experience. Before, when they would go to the store, it was a fun experience. They would go and they would look at things, whether it's, buying groceries or making sure, hey, what's going to be for dinner tonight? This is exciting. We're going to get to pick out vegetables. We're going to get to pick out like meats or fish, and we're going to get to cook. But now it's a completely different experience. You go in there and you're just like, what can I grab that's not too heavy because I just can't carry it? And what can I grab that's just simple because I can't stand there over the stove and cook for 2 hours. I just got to make something simple, or maybe just something like that I just heat up in the microwave and just eat and get my nutrients and be done with it, right? It's a completely different experience. So that's what you have to really focus on with your attorney as a personal injury victim, is the experience of doing. And if you think about that, it really affects everything that you do. And you could even do a day in the life. You could even say, before I had this crash, right? Let's take a day in my life. I would wake up, take a shower, get dressed, and just go through everything. And then how about after this crash? Maybe after the day that you had surgery, do the same thing. I couldn't sleep. I was in pain, tossing and turning all night. I get up out of bed. It's hard for me to put on my shoes or socks, hard to take a shower, bend down. I just go through it. And then you could see how the experience of doing is completely different. And the other thing with pain is that pain is almost like a thief, right? Because it comes in and it's an intruder. You don't want it, but it comes into your house and it starts taking things. And sometimes if it's something very serious, it could take a lot all at once, but usually it'll just take in small increments, and it'll take your pleasures away, your experiences away. And it's also a double taker because it takes away your physical pain, right? The actual pain. Let's say you have a shoulder injury, so you actually feel pain in your shoulder, but it also takes away and it contributes to mental suffering, like thinking about it, depression, anxiety, post-traumatic stress disorder, things like that, and worrying about it, the mental suffering. That's why they call it pain and suffering, because you have the physical and the mental. So it's really important for someone to convey that and to explain that. And then at trial, some lawyers refer to it as the dignity of damages, and talking about what is a fair and reasonable amount for what was taken, and always framing it that way, not how much you're going to get, because it's not about that. Because essentially, if you had a choice, nobody would ever choose to be injured, right? You'd rather have your health, you'd rather be healthy, but unfortunately, due to the defendant's choices, this is the situation you're in. And also, if you think about the nature of damages, it's important to speak with the jury in jury selection, and important to remind them in opening statement, again in closing argument, because people talk about things like an eye for an eye, right? Before, in some societies, they have eye for an eye. So somebody does something and then you do the same thing back to them. But if you really think about it and you go back to the nature of the eye for an eye justice model, it wasn't about the punishment, but rather it's about the full recognition of the harm that was originally caused, right? The magnitude of the loss. And that was the reason for it. And so in our system, obviously, we're not going to go back to something as barbaric as eye for an eye, but we have compensation. And then you have to make sure that the jurors are okay with that, right? Because some people are just not okay with compensation and okay with allowing for compensation, because that's the system that we have. So yeah, let us know what you think. But these are some ideas about pain, about framing it, about building it up, about working it up so that the non-economic damage component, the pain, the suffering, and also the loss of enjoyment of life, which is a component here in New York, that's part of pain and suffering. In other states, you have to look at the pattern jury instructions, and a good trial lawyer will know that, and they'll be able to say, look, I have inconvenience, I have loss of, sometimes you have loss of comfort, and you have other things that you can claim. But it's really important, I think, to give examples, to tell a story, to illustrate each point, to have these independent witnesses, and that way you could really make the pain and suffering verdict much higher. So thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families.